Reflection can be a dangerous thing when the past is something you've been trying to outrun for years. Witness the chrome-sharp reality of justice as it finally catches up to those who thought they were safe. Subscribe today and watch the ultimate price of deception unfold.
The day my brother walked into the attorney's office with a smirk on his face, I was already holding the folder that would destroy him. I did not cry. I did not shake. I sat with my hands folded on the table and I waited. That is the part no one expects from me. Because for 31 years, I was the quiet one, the one who nodded, the one who said okay when nothing was okay, the one who stayed late at the office, wired money home without being asked, and drove 4 hours on Thanksgiving to cook a meal that no one thanked me for. My brother always said I had no spine. My mother always said I was just like my father, meaning passive, meaning soft, meaning easy to move out of the way. They were right, for a long time, and then they weren't. My name is not important. What is important is that I am a forensic accountant. I spend my days finding the numbers people try to hide. I know how to read a document the way a surgeon reads an X-ray, not just what is visible, but what the shadows are telling you. I know where people lie in financial paperwork. I know the exact timestamp a file was last modified. I know that greed always leaves a trail. And my brother is a very greedy man. Let me tell you how this started. Not with the will. The will was just where it ended. It started when I was 22, and our father got sick for the first time. Nothing fatal. Just a warning, the kind that makes a family suddenly very interested in who is in the room when the doctor speaks. My brother, Daniel, had never shown much interest in our parents before that. He had spent most of his 20s borrowing money and not returning it, skipping holidays, and calling only when his bank account was empty. But the moment the cardiologist used the phrase estate planning, Daniel became the most devoted son in the country. He started coming to Sunday dinners. He started calling our mother every morning. He started positioning himself as the responsible one, the present one, the one who actually cared. And I watched it happen the same way I always watch things from the outside, quietly, noting everything. Our father recovered. Life continued. Daniel borrowed more money, this time with the excuse that he was starting a business, and our parents handed it over with the kind of hope only parents are capable of sustaining after decades of disappointment. $20,000, then another 15. Then a third transfer that my mother described vaguely as helping him get on his feet. I asked once. Just once. I said, "Mom, have you seen a business plan? Any documentation of how this money is being used?" She looked at me like I had suggested something obscene. "He is your brother," she said. "Family does not need documentation." I did not argue. I simply remembered what she said. 4 years ago, our father had a second episode, worse than the first. He was in the hospital for 11 days. During that time, I took a week off work and stayed at my parents' house to help my mother manage everything: the insurance calls, the pharmacy runs, the 3 different specialist appointments that needed coordinating. Daniel visited twice, each time for less than 2 hours, and both times I noticed he spent at least 30 minutes alone with our father in the hospital room. I thought nothing of it at the time. I was too busy. I was always too busy doing the actual work to pay attention to what was happening in the margins. Our father came home. He was slower after that, quieter. He had always been a methodical man, an engineer who built things carefully and documented everything. He had a filing system in the study that I had helped him organize when I was 12 years old. Color-coded. Alphabetical within categories. The kind of order that reflects a mind that respects precision. About 8 months after he came home from the hospital, I stopped by on a Saturday to help with some yard work. My father was resting, my mother was out with a neighbor, and I went into the study to find a reference document he had asked me to locate for his Medicare supplemental claim. The filing system was wrong. It was subtle. If you did not know the system the way I knew the system, you would not have noticed. But 2 folders were in the wrong sequence. The color-coded tabs had been replaced. The new ones were close, but not identical to the originals. And the folder labeled Estate Planning had a slight crease in the top corner, the kind you get when a document has been hastily reinserted. I did not open it that day. I told myself I was being paranoid. I found the Medicare document, I did the yard work, I had dinner with my father, and I drove home. But I could not stop thinking about those tabs. 2 weeks later, I came back on a Tuesday afternoon when I knew my father would be at physical therapy and my mother would be with him. I had a reason prepared. If anyone asked I was dropping off a casserole, I had a key. This was completely normal. All of those things were true. I opened the estate planning folder. The will had been updated. Not by an attorney I recognized. My parents had used the same estate attorney for 20 years, a woman in their town whose name appeared on every prior document. This will had been prepared by a different firm entirely, a small outfit 2 towns over that I had never heard of. The date was from 9 months ago, the week after my father came home from the hospital, when he was on 3 medications, sleeping 12 hours a day, and describing himself as not quite right in the head yet. I read the document 3 times. I photographed every page. I put it back exactly as I found it, crease and all. Then I sat in my car in my parents' driveway for 20 minutes and thought about what I was going to do. The will left the house, the investment accounts, and the remaining cash assets almost entirely to Daniel. My share had been reduced to a single line item, a nominal amount described as already provided for through prior gifts, which was interesting, because I had never received a significant gift from my parents in my adult life. Daniel, on the other hand, had received somewhere north of $80,000 across a decade of helping him get on his feet, none of which anyone was apparently counting against him. But that was not the most important thing I noticed. The most important thing was the signature. My father's handwriting is distinctive. I have seen it on birthday cards, on engineering drawings, on checks and letters for 31 years. I know the way he makes his capital R, the slight leftward lean of his letters when he is tired. I know that he always prints his middle initial with a period after it, without exception, because he told me once that a document without proper punctuation is a document that does not respect itself. The signature on this will had no period after the middle initial. I drove home. I did not call anyone. I made dinner, I watched something I cannot remember, and I went to bed. And while I lay there, I made a list in my head not of what I felt, but of what I needed. I needed the original will, the one from the attorney my parents had used for 20 years. I needed a handwriting analysis. I needed to understand what prior gifts referred to specifically, because if it did not correspond to any actual financial transfers to me, that language was fabricated. I needed to know who had prepared the new document and whether my father had ever actually appeared in person at that firm. And I needed time. I needed everyone to believe that I had noticed nothing. That part was easy. I had been performing, noticed nothing my entire life. I called the original estate attorney's office and identified myself as the daughter of a long-standing client. I said I was trying to understand the family's estate planning situation in order to help coordinate care decisions. This was not a lie, not technically. The assistant told me that the firm had not prepared any new documents for my parents in over 6 years, and that the most recent will on file for my father had been executed in 2017. So there were 2 wills. One from 2017, which my parents' longtime attorney had on file, and one from 9 months ago, which had appeared in the filing cabinet while my father was medicated and recovering, and not quite right in the head yet. I hired a private handwriting examiner. I did not tell her the context. I sent her a scanned copy of my father's signature from 3 different undisputed documents, a birthday card from 2 years ago, a letter he had written to his insurance company, and a signed receipt from a contractor alongside the signature from the new will. I asked for a professional opinion. Her report came back in 10 days. She used careful language, the kind experts use to protect themselves in potential litigation. But the conclusion was clear. The signature on the new will showed significant inconsistencies with the confirmed samples. She noted the missing period, an unusual pen pressure distribution, and an inconsistency in the letter spacing that was, in her professional opinion, not consistent with natural variation due to age or illness. I added the report to the folder. Then I started looking at the money. I had access to a shared family budgeting account my parents had added me to years ago, when my father's first health scare made them want another set of eyes on their finances. I had never abused that access. I had used it exactly as intended to help them spot unusual charges, to flag a fraudulent credit card transaction once, to make sure their automatic bill payments were processing correctly. I was the responsible one. I was always the responsible one. Over the preceding 14 months, there had been 12 transfers to an account I did not recognize. Each one was under $10,000, the threshold that triggers automatic bank reporting, and each one was spaced at least 30 days apart. The total came to just over $94,000. The destination account belonged to a holding company. The holding company had been registered in Delaware 8 months before the first transfer. The registered agent was a service firm that handled incorporation paperwork for dozens of anonymous LLCs. But the contact email address, buried in a public state business registration record that most people would not know to look for, had a domain suffix I recognized. It was a variation of the name of Daniel's business. I printed everything. I organized it the way my father had taught me to organize things methodically, precisely, with a table of contents and page numbers. I made 3 copies and stored them in 3 different locations. And then I waited. I want to explain something about waiting, because people assume it is passive. It is not. Waiting, when you are doing it correctly, is the most active thing you can do. While I was waiting, I was watching. I noticed that Daniel had started accompanying our mother to her bank appointments. I noticed that she mentioned, casually, that she and Daniel had been getting everything organized. I noticed that she started referring to the house as something that would stay in the family, with a particular emphasis that felt pointed. I also noticed that my father seemed confused sometimes in a way that was new. Not dramatically, he was not incapacitated, but he would start a sentence and lose the thread. He would ask me the same question twice in an hour. He was not the man who had taught me that a document without proper punctuation does not respect itself. I made an appointment with his primary care physician. I identified myself as his daughter and requested a cognitive assessment, citing specific observations with dates. The physician took it seriously. The assessment happened 3 weeks later. The results were not catastrophic, but they were significant. My father had mild to moderate cognitive impairment, consistent with early-stage vascular dementia. The physician documented that his decision-making capacity for complex financial and legal matters should be considered limited, and that any major documents executed in the past 12 to 18 months should be reviewed. I asked for a copy of the report. I added it to the folder. 6 weeks after that, Daniel made his move. He came to my parents' house on a Sunday when I was also there, which I believe was intentional, because he wanted an audience, or perhaps because he wanted to see how I would react. He sat down at the kitchen table with a calm, proprietary ease that made my jaw tighten, and he told my mother that it was time to get the estate in order before anything happened, and that he had already spoken to an attorney who could help transfer the house into a trust. My mother looked at me. I smiled. I said, "That sounds like something worth thinking about carefully." Daniel looked at me with something I can only describe as contempt. He had always found my calmness irritating. He interpreted it as weakness. He thought it meant I did not understand what was happening. He was wrong. 3 days later, I called an estate litigation attorney. I had researched 7 attorneys in the region and selected her based on her specific experience with undue influence cases and financial elder abuse. I sent her the folder before our first call. When we spoke, she was quiet for a long moment after I finished summarizing the contents. "You have been thorough," she said. "I had a good teacher," I told her. "My father." We filed a petition to contest the validity of the newer will based on 3 grounds: lack of testamentary capacity, undue influence, and potential fraud. Simultaneously, she sent a formal letter to the firm that had prepared the document requesting all records related to the execution of the will, specifically, any video, photo, or written record confirming my father's in-person attendance and his demonstration of understanding the document's contents. The firm took 11 days to respond. They said their records indicated the will had been executed at the client's residence, not at the office. They said the witnessing had been handled by 2 individuals whose names appeared in the document. One of those names, when I looked it up, corresponded to a person who had been an employee of Daniel's holding company at the time. I forwarded that to my attorney. The hearing was scheduled for a Tuesday. I drove to the courthouse alone. My mother did not know the full extent of what I had filed. I had told her only that I had some concerns about the estate documents and that I had asked an attorney to review them. She was upset. She told me I was making things difficult, that I was being suspicious for no reason, that Daniel had only ever tried to help. I said, "I know you believe that. I hope I'm wrong." I was not wrong. Daniel arrived at the hearing with his own attorney, a man who had the practiced confidence of someone used to being the most prepared person in the room. He was not the most prepared person in this room. My attorney laid out the timeline first. The original will, on file for 6 years, executed when my father was in full health, witnessed by 2 people with no financial connection to either sibling. Then the new will executed during a recovery period now documented as cognitively impaired, witnessed by 1 person with a direct employment connection to Daniel, prepared by a firm my parents had no prior relationship with. Then she presented the handwriting analysis. Then the cognitive assessment. Then the banking records $94,000 transferred in structured amounts to a company traceable to Daniel over 14 months, beginning shortly after my father's second hospitalization. Daniel's attorney objected to the framing. He said the transfers were loans, documented and consensual. My attorney asked him to produce the loan documentation. There was a pause. There was no documentation, because they were not loans. They were withdrawals from a man who was increasingly unable to track what was being taken from him. The judge was a woman in her 60s with the kind of face that reveals nothing while it processes everything. She asked Daniel's attorney several questions. She asked my attorney several questions. She reviewed the handwriting report in silence for what felt like a very long time. Then she looked at Daniel directly, and she asked him when, specifically, he had been present when his father signed the newer will. Daniel said he had not been present. He said he had dropped his father off at the attorney's office and waited in the car. My attorney noted, for the record, that the firm had stated in writing that the will was executed at the client's residence, not at their office. Daniel looked at his attorney. His attorney looked at the table. I looked at my hands. The judge set a continued hearing date and ordered a full forensic review of both the will's execution and the financial transfers. She also issued a temporary freeze on any transfers of property or assets pending the outcome. She referred the matter to the state's Adult Protective Services Division for a separate inquiry into potential financial elder abuse. Daniel was very quiet on the way out. I walked behind him and my mother to the parking lot. My mother did not speak to me. She got into Daniel's car and they drove away. I sat in my own car and I thought about my father, who was home with a part-time aide that I had arranged, doing a word puzzle because his doctor had recommended it for cognitive maintenance. He had called me the night before and asked me twice when I was coming to visit. The second time he asked, I do not think he remembered asking the first time. I thought about the filing cabinet with the color-coded tabs. I thought about how he had built that system when I was 12 and explained every category to me with patience and precision because he believed that a person who understands how to organize information will never be helpless. He gave me that. He gave me the tools to do exactly what I had done. The forensic review took 4 months. At the end of it, the court invalidated the newer will on all 3 grounds. The 2017 will was reinstated as the controlling document. Under that will, the estate was divided equally between Daniel and me. The Adult Protective Services inquiry resulted in a formal finding of financial exploitation. Daniel was required to repay the $94,000 to my parents' estate. The case was referred to the district attorney's office for review of potential criminal charges. I do not know, as of the time I am telling you this, what has come of that referral. What I know is that it exists. It is on record, and the district attorney's office does not file things away without reading them. My mother called me 6 weeks after the final ruling. It was a short conversation. She said she did not understand how things had gotten this far. She said she wished I had come to her first. I reminded her, gently, that I had. I had asked once, years ago, about documentation, about whether gifts to Daniel were being tracked. She had told me that family does not need documentation. She was quiet for a moment. Your father always said you were the careful one, she finally said. Yes, I told her. He did. We are not close right now, my mother and I. I think she is still sorting through the grief of understanding what Daniel did and what she allowed and what she missed. That is her work to do. I cannot do it for her. I have spent enough years trying to do work that belonged to other people. My father and I have lunch every other Sunday. His aide brings him to a restaurant near his house, and I drive up and we sit for 2 hours, and I let him set the pace of the conversation. Some days he is sharp, and we talk about engineering and crossword clues and the news. Some days he circles back to the same story twice, and I listen to it twice, and I find a way to appreciate it both times. Last month he told me, in one of his sharper moments, that he was glad I had found the folder. I told him I was glad he had taught me how to build one. He nodded at that. He picked up his coffee cup and looked out the window for a moment, and then he looked back at me with the steady, clear eyes that remind me he is still in there, still himself, even on the days when the words get tangled. A document without proper punctuation, he said, does not respect itself. No, I said, it doesn't. And that was the whole conversation. That was everything.